A very warm welcome to all my listeners. I, Dhruvi Sikarwar from AIHRA Society, welcome you all in today's session, which is about the 73rd Constitutional Amendment Act. So let's get started. Panchayat Raj, the 73rd Constitutional Amendment Act. A three-tier structure of the Indian administration for rural development is called Panchayat Raj. The aim of the Panchayat Raj is to develop local self-governments in districts, zones and villages. Introduction to Panchayat Raj. Rural development is one of the main objectives of Panchayat Raj, and this has been established in all states of India except Nagaland, Meghalaya and Mizoram, in all union territories except Delhi, and certain other areas. These areas include the scheduled areas and the tribal areas in the states, the hill area of Manipur for which a district council exists, and Darjeeling district of West Bengal for Darjeeling Gorakh Hill Council exist. The 73rd Constitutional Amendment Act of 1992. Here are some significance of the Act. The Act added Part 9 to the Constitution, which is the Panchayat, and also added the 11th Schedule, which consists of 29 functional items of the Panchayat. Part 9 of the Constitution contains Article from 243 to Article 243O. The Amendment Act provides shape to the Article 40 of the Constitution, which is called Directive Principles of the State, which directs the state to organize the village panchayat and provide them with powers and authority so that they can function as self-government. With the Act, Panchayat Raj system come under the purview of the justiciable part of the Constitution and mandates state to adopt the system. Further, the election process in Panchayat Raj institutions will be held independent of the state government's will. The Act has two parts, compulsory and voluntary. Compulsory provisions must be added to state laws, which includes the creation of the new Panchayat Raj system. Voluntary provisions, on the other hand, is the discretion of the state. The Act is very significant step in creating democratic institution at the grassroots levels in the country. The Act has transformed the representative democracy into participatory democracy. Now, let's move on to the salient features of the Act. First is Gram Sabha. Gram Sabha is the primary body of the Panchayat Raj system. It is a village assembly consisting of all the registered voters within the area of the Panchayat. It will exercise powers and perform such functions as determined by the State Legislature. Candidates can refer to the functions of the Gram Panchayat and Gram Panchayat work on the government official website. Second feature is that it is three-tier system, which means the Act provides for the establishment of three-tier system of Panchayat Raj in the states, which is first village, second intermediate and third at district level. States with a population of less than 20 lakh may not constitute the intermediate level. Third is election of the members and chairperson. The members to all the levels of the Panchayat Raj are elected directly, and the chairperson to the members, and at the village level, the chairperson is elected as determined by the state government. Fourth, we have reservation of seats. For SC and ST, reservation to be provided at all three tiers in accordance with population percentage. For women, not less than 1/3 of the total number of seats to be reserved for women. Further, not less than 1/3 of the total number of offices for chairperson at all levels of the Panchayat to be reserved for women. The state legislatures are also given the provision to decide on the reservation of seats in level of Panchayat or office of chairperson in favor of backward classes. Fifth feature is duration of Panchayat. The Act provides for a 5-year term of office to all the levels of the Panchayat. However, the Panchayat can be dissolved before the completion of its term, but fresh elections to constitute the new Panchayat shall be completed before the expiry of 5-year duration. Secondly, in case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. Sixth feature is disqualification. A person shall be disqualified for being chosen as or for being a member of Panchayat if he is so disqualified. Firstly, under any law for the time being in force for the purpose of elections to the legislature of the state concerned. Secondly, under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has been attained the age of 21 years. Further, all questions relating to disqualification shall be referred to an authority determined by the state legislature. Seventh is State Election Commission. The Commission is responsible for superintendence, direction and control of the preparation of electoral rolls and conducting elections for the Panchayat. The state legislature may make provisions with respect to all matters relating to elections to the Panchayat. Eighth feature is about the powers and function. The state legislature may endow the Panchayat with such powers and authority as may be necessary to enable them to function as institution of self-government. Such a scheme may contain provisions related to Gram Panchayat work with respect to the preparation of plans for economic development and social justice, the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 29 matters listed in 11th Schedule. Ninth we have is about the finance. The state legislature may authorize a Panchayat to levy, collect and appropriate taxes, duties, tolls and fees. Assign to a Panchayat taxes, duties, tolls, fees levied and collected by the state government. Provide for making grants in aid to the Panchayats from the consolidated fund of the state. Provide for the constitution of funds for creating all money of the Panchayat. 10th is Finance Commission. The State Finance Commission reviews the financial position of the Panchayat and provides recommendations for the necessary steps to be taken to supplement resources to the Panchayat. 11th is Audit of Accounts. State legislature make provisions for the maintenance and audit of Panchayat account. 12th, Application to Union Territories. The President may direct the provisions of the Act to be applied on any Union Territory subject to exceptions and modification he specifies. 13th, Exempted States and Areas. The Act does not apply to the states of Nagaland, Meghalaya, Mizoram and other states of areas. 14th, Continuation of existing laws. All the state laws relating to Panchayat shall continue to be in force until the expiry of 1 year from the commencement of this Act. In other words, the states have to adopt the new Panchayat Raj System based on the Act within the maximum period of 1 year from 24th April 1993, which was the date of the commencement of this Act. However, All the panchayat existing immediately before the commencement of this act shall continue till the expiry of their term, unless dissolved by the state legislatures sooner. 15. Bar to interference by the courts. The Act bars the court from interfering in electoral matters of panchayat. It declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. It further lays down that no election to any panchayat is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislature. Thank you so much. I hope you all got a glimpse of the 73rd Constitutional Amendment Act of Panchayati Raj System. Take care.